Hello, this is Jonathan Riley of Lawrence Graham welcoming you to our webinar today under the title Warranties, Covenants, Guarantees and Indemnities. This webinar is presented by Lawrence Graham's Commerce and Technology Group as part of our SmartLaw programme, and I'm joined today by my colleagues and fellow group members Vanessa de Frobeville, Alex Beale and Ed Cooper, with a special guest appearance by Verity Barker from our Dispute Resolution Group. The format for today is that we will have 5 presentations, each of around 10 minutes, and then we'll conclude with a Q&A session and aim to close in around an hour's time. You'll see from the slide on your screens at the moment that there's a dialogue box for you to submit any questions at any time during the presentations. We'll receive and collate those questions and then discuss the most popular questions and issues raised in the Q&A session at the end of the presentations. I would add, though, that we have a lot of participants registered for this session, and so I apologise in advance if we haven't addressed all of the questions sent in by the end of the Q&A session. The purpose of this webinar is to take a fresh look at some familiar contract terms and contract law principles and the role that they play in securing the performance of a party's obligations, including the remedies available for a breach. We'll start with a reminder of the default position for a contractual obligation, looking at the damages remedy for an ordinary breach of contract, and then move to consider the different terms in which an obligation might be expressed and the distinctions between those terms. What's the difference between a representation and a warranty and an indemnity and a guarantee? Should the party covenant, undertake or promise, and how do you choose the correct option? Finally, we consider whether those distinctions will really matter if a breach of contract occurs in terms of pursuing legal remedies, including framing a legal action. Now I'm pleased to start our presentations by introducing Vanessa de Frobeville with our first presentation, which begins at the logical starting point. What are the legal remedies for an ordinary breach of contract, which will set the context against which we can then go on to look at whether and how warranties, covenants, guarantees and indemnities add to or alter those remedies. Vanessa.
Thanks, Jonathan. In this session, I want to go right back to basics as a preparation for the more detailed sessions from Alex, Jonathan, Ed and Verity. So I'm going to have a look at the basics of contract law in the event that there is a breach of contract. Secondly, what flows from a breach of contract, and damages. And I'm also going to have a look at some cases in relation to remoteness of damages. I thought this approach might be helpful as it sets out the position where a contract does not include any express remedies for breach, termination, consequences of termination, etc. So going back to basics, let's look at the position under contract law. A breach of contract occurs where a party, without lawful excuse, fails or refuses to perform or does not perform precisely and exactly their obligations under the contract. This breach can entitle the injured party to claim for damages. The breach may also allow the injured party the right to terminate the contract, and we'll have a look at this in a minute. So where a contract does not include any express remedies for breach, such as an indemnity, one of your recourses is simply to terminate the agreement. A breach of contract does not automatically bring the contract to an end. Rather, a contract gives various options to the innocent party. The extent of these options depends on the seriousness of the breach. Even the most serious breach, such as a fundamental breach, of itself always terminate or discharge the contract. The consequences of a breach of contract depend on the facts of each case, but there are 3 principal consequences of a breach of contract. The first, that the innocent party is entitled to recover damages in respect of the loss which they have suffered as a result of the breach. The second, the party in breach may be unable to sue to enforce the other party, that's the innocent party's obligations under the contract. And the third, the breach may entitle an innocent party to terminate the performance of the contract, and the rest of the team will have a look at this in more detail in a minute. Now, looking at damages. Every breach of a valid contract gives the innocent party the right to claim damages regarding the loss they have suffered as a result of the breach. That is, unless the liability for the breach has been excluded by the limitation of liability clause in a contract, which may be the case. Also, some losses are too remote to recover, and I'm going to have a look at this in more detail. I'm not going to go into the different types of damages or the different tests for measuring damages in contract, as that's probably more one for Verity. Instead, I want to look at the issue of remoteness and how this restricts the recovery of damages. Not all losses that flow from a breach of contract are recoverable. Damages for breach of contract are restricted. sometimes losses will be viewed as too remote to be recoverable. Now, under contract law, the test for remoteness is set out in Hadley and Baxendale. This is the holy grail of all damages cases. The facts were as follows. This related to a flour mill in Gloucestershire. The crankshaft of their steam engine was broken so that the mill couldn't function. They arranged with the defendant carriers for the shaft to be taken to a third party who agreed to make a new shaft using the old one as a model. However, the defendants broke their contract by delaying the delivery of the new shaft. So the plaintiffs sued to recover the profits they would have made had the mill started again without delay. And the court rejected this argument, saying that basically the breach was not in contemplation of the parties at the date of making the contract. Now, Hadley and Baxendale establishes a two-pronged test. Under this test, the claimant will be able to recover for the losses arising naturally according to the normal or ordinary course of things from the breach of contract, and such loss as may reasonably be supposed to have been in contemplation of the parties at the time they made the contract. The first limb of the test is objective and refers to so-called general damages. This test is concerned with what a reasonable man should have known to be the ordinary course of things, that is, within his reasonable contemplation, and this is often known as direct loss. The second limb of the test covers knowledge of special circumstances outside the ordinary course of things. The question is, what could have reasonably been contemplated by the parties in breach at the time? And this second limb covers so-called special damages, sometimes known as indirect losses or consequential losses, and makes these additional losses recoverable. Now, to answer what exactly is a direct loss as opposed to an indirect loss will be a question of fact in the circumstances. The test under Hadley and Baxendale is always applied, but in recent years the courts have sometimes found that the test is not always appropriate. And I want to have a look at a further few cases where this was discussed. The first case I want to have a look at is the Transfield shipping case. And this was a House of Lords case where they confirmed the proper measure of recovery when there had been late delivery under a charter party agreement. It was held that it would not ordinarily be the case, nor would it have been the party's intention that such a short delay would expose the charterers to considerable liabilities, and the loss was too remote to recover. But the judges actually took varying approaches in formulating the judgment, and some proposed a new approach to the remoteness test. And that was whether the loss was one which the defaulting party could reasonably be regarded as having assumed responsibility for. Because this was a House of Lords case, there was much debate as to whether they had found an alternative to the Hadley and Baxendale test, and whether the new test had been established. The next case I want to have a look at is the Super Shield case, which was decided in the Court of Appeal. This related to the flooding of an office due to a faulty sprinkler system and blocked drains. The Super Shield case considered the Transfield shipping case further, but said that the Hadley and Baxendale test of direct and indirect loss remained the standard rule. But there may be exceptional circumstances where the court, considering both the contract and the commercial background, may decide that the standard approach would not meet the expectation or intention of the parties, and so would not give an equitable result in that case. The last case I want to have a look at is the Sylvia shipping case. This also related to the late delivery of a ship, and this case has further clarified the applicability of the test under the Transfield case. The judge thought that it was important to make clear at the outset that there was no new general applicable legal test of remoteness in damages. The court stated that the orthodox approach under Hadley and Baxendale remains the general approach which will apply in the vast majority of cases, and, I quote, "it works perfectly well." But the court did still confirm that, as indicated, the Transfield and Super Shield cases, there may be scope in certain unusual cases, and depending on the context and surrounding circumstances, to have a new assumption of responsibility case. But this would only occur in very rare cases. So the Hadley and Baxendale case still holds, except in very exceptional circumstances where the Hadley test gives an unpredictable, unexpected result, or where the courts In that case, we'll have a look at the assumption of responsibility test under the Transfield case. So in conclusion, as a very quick recap, a breach of contract is committed where a party fails or refuses to perform its obligations under a contract. A breach of contract allows a party to claim for damages. The aim of an award of damages is to compensate for the loss which has been suffered. It is not to punish the defendant. Generally, the damages cannot be recovered where the loss which has been suffered is too remote. However, there is a new assumption of responsibility test, but this is going to be applied in only very exceptional circumstances. And with that, I'm going to hand you back to John.